The landscape of employment law in the UK is undergoing a significant transformation. The proposed Employment Rights Bill brings stronger protections for workers, clearer rules on job security, and new legal duties for employers. It tackles long-standing issues like zero-hour contracts, unfair dismissal, and flexible working. If passed, it will shape how we work, hire, and manage staff for years ahead. Hi, I'm Hinna Raja, a paralegal in the employment team at Anthony Gold Solicitors, and in this video, I'll explain what's in the bill, what it means in practice, and when it's likely to take effect. So, what is the Employment Rights Bill? It's a new piece of legislation still making its way through Parliament. The aim is simple: to update the rule around work in a way that reflects how people actually work today. It's part of the government's plan to make work pay, and it includes a range of reforms for all types of employers, from large organisations to small businesses. Some of the biggest proposals include a right to request flexible working from day one, a clearer legal framework for guaranteed hour contracts, and better protections against unfair dismissal. The idea is to make job security and predictability a legal standard, not a perk. For employers, this means some important new responsibilities. For workers and employees, it could mean more control over how and when you work. The bill isn't law yet, but it's expected to come into force in stages, starting later this year. So now's the time to prepare. Now, let's look at some of the key changes proposed in the Employment Rights Bill. Number 1, unfair dismissal protections. One of the biggest changes is the introduction of unfair dismissal rights from day one in certain cases. At the moment, employees usually need 2 years' service to make a claim. Under the bill, that would no longer apply in situations involving flexible working, working hours, or whistleblowing. There'll also be a new statutory probation period, expected to be 9 months, where employers can use a lighter dismissal process for things like conduct or capability, but not redundancy. This shift means contracts and internal procedures will need a proper review. Number 2, guaranteed hour contracts. To address instability of zero-hour work, the bill introduces guaranteed hour contracts. These will set a legal minimum number of hours an employer must offer, giving workers more financial stability. It's a major change for sectors like hospitality, retail, and logistics. Employers who don't meet their obligations could face claims or compensation orders, so reviewing contracts and shift systems will be essential. Number 3, flexible working from day one. The right to request flexible working is being strengthened. Employees will no longer need 26 weeks service. They'll be able to make a request from their first day on the job. They'll also be allowed 2 requests per year, and employers will have just 2 months to respond. The process is being simplified, but employers still need solid lawful reasons for any refusal and must consult with the employee before saying no. Number 4, enhanced leave rights. Leave rights are also being expanded. Paternity leave will be available from day one, with more flexibility on when it's taken. Neonatal care leave gives parents up to 12 weeks of paid time off if their baby is in hospital early in life. Bereavement leave will become a legal right too, with at least 1 week of paid leave. All of these entitlements will need to be built into policies and properly communicated to staff. Number 5, protections for agency and precarious workers. Agency workers, freelancers, and those in non-standard roles are also set to gain more protection. The bill promises fairer treatment, guaranteed hour options, better notice of shift changes, and stronger pay transparency. A new Fair Work agency is also being considered to oversee enforcement. If you rely on casual staff, it's important to get ahead of these changes now. Number 6, stronger tribunal powers. To back all this up, employment tribunals will be given more power. Claim time limits will increase to 6 months. Compensation levels will rise, and aggravated damages will be available in more serious cases. Tribunals will also have a greater authority to issue enforcement orders. Employers who fall behind on compliance could face serious costs and legal risks. I've prepared a more detailed breakdown of all the key proposed changes in my blog. If you're interested in learning more, please check out the link in the description. What does this mean for employers? For employers, the Employment Rights Bill brings new legal duties that can't be ignored. It's a chance to create a more transparent and fair working environment. But it also means contracts, policies, and internal procedures will need reviewing. Some key areas to focus on include updating employment contracts and handbooks to reflect new rights, rethinking flexible working and dismissal processes, budgeting for extra costs linked to guaranteed hours and new types of leave, making sure HR and management teams understand the new legal standards. Industries like retail, hospitality, logistics, and transport, where casual and part-time work is common, will be particularly affected. Planning ahead now is essential. What does this mean for employees and workers? For workers and employees, these reforms offer stronger protection, better work-life balance, and more immediate access to legal rights. Some of the key improvements include protection from unfair dismissal from day one in specific cases, more predictable hours and secure contracts, the right to request flexible working from the start, and new leave entitlements for carers, parents, and those facing bereavement. If you're not sure whether your employer is meeting these new standards once they come into effect, it's worth getting advice. At Anthony Gold Solicitors, we help both employers and individuals navigate changes in employment law. If you have questions about what the Employment Rights Bill means for you or your business, our team is here to support you. Call us on 020-7940-4060 or email us at mail@anthonygold.co.uk.